imagining that that really was a band, even though that's not your opinion, to look at the typing results for the substrate control to see if that imaginary band appears there.
Objection vague as to what typing results?
Yes, when we want to look at the substrate control, and if banding did occur in the substrate control, or if any DNA was detected there, then you would want to compare that to your evidence sample.
Okay, and do you recall what your typing results were for stain number 50, one of those Bundy walk stains?
I'll have to look at the report and my notes.
While you're doing that, this imaginary band that you've already described was not there. Where did it line up with respect to the latter?
Your Honor, I object to the term imaginary being argumentative.
Sustain. Rephrase the question.
Imagining that that really was a band, okay, which
Yes.
I'm forcing you to do in this question, where did that band that I've asked you to imagine line up with?
Well, as when Mr. Blasier was, excuse me, asking me, we saw that it was right in between the, I believe it was the 17. But let me look at my notes again to be sure of that. Mr. Harmon, what gel number was it? Analytical gel number?
So 184?
184 is what I've written down.
Thank you. The evidence sample, DNA A LAPD number 50 from the Bundy crime scene came back at 2425.
Okay, could we project 275C up, Your Honor? Okay, now if you recall Exhibit 275C, you want to take a look at it? That actually...
Yeah, I'm going to object. We approach.
Oh. Okay, why don't you can turn that off. The bands in that stain were 2425, is that true?
That's correct.
And nothing appeared in the area that the band that I've asked you to imagine appearing in 50 control, is that true?
That's correct.
And even if that band that I've asked you to imagine was on the 50 control, the fact that you see nothing on the 50 stain, what's the significance of that? And I'm asking you to imagine something that's contrary to your scientific opinion.
Well, the only banding pattern that was seen on the evidence sample that relates with that substrate control was a 24 band and a 25 band. There were no bands seen in any other region of that gel. That's it.
Okay, let's move to the proficiency tests that were shown up on the screen by Mr. Blasier. Did you know that the correct answer to the quality control sample on that proficiency test was a 1.13?
No, I did not. These are blind, or they're unknown to me. The results are unknown to me when I'm doing the analysis.
Did you make up the explanation of cross-hybridization for describing in your notes on the result sheet what you saw in that QC result?
No, cross-hybridization is documented in a lot of the literature.
Is it listed in the manufacturer's user guide on page 6-5?
Yes, it is noted in the Roche user's guide.
Okay, is it also mentioned in Dr. Blake's casework article, The Phenomenon of Cross-Hybridization, on page 704?
Dr. Blake does mention cross-hybridization in his 1992 casework paper. As far as the exact page, you'd have to show me the document.
And moving to the test sample and in your proficiency test, when you wrote down what your opinion was when you saw the data, did you know that the correct answer was 1.23?
No, I did not.
Mr. Blasier put up the gel where the 3 reference samples were initially run, and you described that you were unable to type Mr. Simpson. Do you recall that yesterday?
Yes. Mr. Simpson's sample gave no results on the first amplification.
Okay, and your explanation for that was PCR inhibition. Do you recall that?
Correct.
Did you make up the explanation inhibition to explain that?
No, I did not.
Is the subject of inhibition, PCR inhibition, mentioned in the user guide by the manufacturer of these kits?
Yes, it is.
Is it also mentioned in Dr. Blake's casework article on page 719?
Yes, Dr. Blake does mention it. As far as the exact page, I would have to look at the document.
Is it also mentioned in the chapter 17 that was authored by Dr. Blake and Cecilia von Berelding on page 214, the subject of PCR inhibition?
Chapter 17 of the PCR technology book?
Yes.
Yes, it's addressed, inhibition is addressed in that article also.
Is it also addressed in the analytical chemical article that we've discussed, authored by Dr. Blake and Becky Reynolds from Roche?
The article by Dr. Blake and Dr. Reynolds does mention inhibition also.
And is also discussed in a chapter in a book, the Saperstein book, the way we've described it, the authors of which are Dr. Blake and Dr. Sensabaugh, the subject of PCR inhibition.
Well, Saperstein has 3 books out, and in the 3rd edition, there's a chapter devoted to, the chapter I believe you're referring to is PCR, devoted to PCR, and there is mention of inhibition in that chapter.
And is there also an article by Dr. Blake?
Excuse me,
and
Counsel, aren't we getting cumulative at this point?
It's my last article, Your Honor.
All right, last one.
It was the phenomenon documented by Dr. Blake and Mr. Higuchi, who's also, or Dr. Higuchi, who's also from Roche, in a 1989 symposium paper that was published in the FBI symposium. You want to take a look at that one?
Yes, can I take a look at that?
The name of the article is PCR Inhibition in Blood Stains.
Yes, I recognize this article, and it does discuss inhibition in this article also.
And when faced with the prospect of PCR inhibition or strike that, do all of these articles also discuss what you do when you think there's PCR inhibition?
Yes, if inhibition occurs with the sample, and by inhibition you don't get any typing results, no products obtained from that sample, analysis should be reconducted to try to get a result from that sample. And it could be reconducted by either diluting the sample, out and then reamplifying it.
Okay, and is that what you did?
Yes, I did.
And in your opinion, is that what any responsible forensic scientist would do?
Yes.
Okay, now did you see, do you remember Mr. Blasier showed those graphics, one about the glove and that purported to show the locations of stains where the 25 allele were found? Do you recall that yesterday?
Yes, I do.
Could we put that up on the screen, Your Honor?
All right, this is the defense exhibit.
1173C.
Okay, have you had a chance to look at that?
Yes.
And are you familiar with the sampling of the glove and the relationship of the stains that were typed by you and Mr. Sims that produced that detected the 25 allele?
Yes, I've reviewed some photographs.
Is that slide misleading in terms of the location of the stains?
Objection, argument.
Sustained. Further question.
How misleading is that slide with respect to showing where those stains
Counsel.
actually are?
Counsel. Rephrase the question.
Does that slide accurately reflect the location of the stains which produced the 25 allele?
Well, I think the best depiction would be to see the actual photograph, to see,
Objection, non-responsive.
Overruled.
Why is that?
because that's the actual documentation of this item.
Okay. Would you like to do that, please? Good. We'll put the boards up. You just stay right where you are. A and B, Your Honor, the exhibit numbers. Montgomery, I want you to look at the slide again. From looking at that, can you tell whether that's a right-hand glove or a left-hand glove?
I believe it could be either glove, depending on the orientation of the hand.
Okay, would you look at 272B, the photo board, and if you could, take the pointer and show us where those stains really are on that right-hand glove, number 9 from Rockingham.
Objection, argument.
Sustained. Rephrase the question. And Mr. Harmon, how about if we take that board and put it on the main easel? You can put it on top of the results board
Okay,
because it's the height of that exhibit in that location.
sure. I just
Such
wanted
a-
to have them both together. That's fine.
All right. All right, rephrase the question, please.
Okay, would you point out to the jury where the stains which produce the 25 allele are, or where they were?
Once again, just by looking at my notes to get the exact item numbers. A 25 allele was detected on G10. And there was also a 25 on...
Okay, and just, because these are inside-out photos, 2 of them, and one is right-side out, could you make it real clear what surface that's on and where it is? Just describe it in words, please.
Okay, G10 is the inside surface near this rich wrist notch. And the results of G10 were a 24 allele and a weaker 25 allele.
Okay, next stain.
There was also a 25 allele detected at G11, and G11 is the outside palmar surface of the glove. And what was detected here was a 24 allele and a weaker 25 and 18 alleles.
Okay,
On G13, which is also the outside surface of the glove, there was, near the notch area, There was a 24 allele detected, and also weaker 25 and 18 alleles detected in this region.
Okay, thanks, Ms. Montgomery. You can go back and have your seat. Mr. Blasier asked you about a problem you had with one of the glove gels. Do you recall that, with the ladder leaking?
Yes, I do.
And your solution to that was to rerun the test, is that right?
Yes. Anytime I'm not confident with the results, or if there's any question in the results, I will do a reanalysis on those samples.
And in fact, did you get the same answers when you reran that gel that you did on the gel where the ladder leaked into the lane?
Yes, for the evidence samples and the controls, I obtained the same results.
And is that what a responsible forensic scientist would do when faced with that problem?
Well, I think any individual, when there's a question, needs to do reanalysis on samples.
And Mr. Blasier projected AG 295 up there, the rear gate gel. Do you recall that yesterday?
Yes, I do.
Okay, and in your opinion, you described what was on there that he directed your attention to as not a problem. Is that true?
Could you state specifically what the problem he addressed on that gel was?
Ms. Montgomery, why don't you pull the microphone a little closer?
Sure.
Thank you.
You know, I don't really recall. We heard about a lot of problems yesterday. Do you recall that there was a problem, perhaps a band, a line of bands that went all the way across the gel, or a line of shadows that went across the gel?
Well, I'll look at that gel and see if that's the one that had the silver smearing across the bottom region. And this is a beautiful gel. I don't know what problem could have been mentioned in this.
If there had been a problem, could any responsible forensic scientist have rerun it?
Yes, if a problem was detected, the gel should be rerun.
Okay, but you saw no reason to do that in this case, is that correct?
That's correct.
There was a lot of discussion yesterday about terms that you've used to communicate data that you saw. A hint, a trace, possible trace. Do you recall those discussions?
Yes.
Do the words that you use to try to communicate or convey the data, do they somehow change the data?
No, they don't.
Okay. So the data is what you've shown this jury, is that correct?
That's correct.
And the words are words you've used to try to express that so that they can appreciate it?
Correct.
Mr. Blasier asked you some words about examiner bias yesterday, or some questions about examiner bias. Do you recall that?
Yes, I do.
I want to ask you a question about examiner bias. Can you make a 24-25 result look like an 18 by wishful thinking?
No, you can't.
Did anything arise in the course of Mr. Blasier's questioning of you that in any way undermines the results that you and Mr. Sims have presented to this jury?
No, there was nothing.
If a responsible forensic scientist had questions about the results you have presented, could she have performed retesting to address the questions scientifically?
Yes, anytime there's a question, reanalysis can be done on these samples. The ones where there were questions, reanalysis was done.
And could that reanalysis be done using PCR product that you conserve?
Yes.
Could it be done using samples, swatches that you preserve?
Yes.
And could it be used on extracted DNA that you preserved in this case?
Yes, if any extracted DNA remains.
Okay. Thanks, Ms. Montgomery.
All right, Mr. Blasier?
Thank you. Ms. Montgomery, yesterday before lunch, or at lunch, I gave you every picture that I was going to use, didn't I?
Yes, you did.
And I told you to look at them and compare them to your gels, didn't I?
Yes, you did.
And I told you to look at them and compare them to the originals of your gels, not the blue films, right?
I don't recall if you specifically said to compare them to the originals or the copies.
You didn't have the blue films, did you? They were in evidence.
Oh, no, I make multiple copies of the blue film, or of the gel, both for discovery purposes and also to retain copies for the case files.
And I told you that I wanted you to look at them carefully to make sure that they were accurate pictures, that they accurately portrayed what you have on your films, didn't I?
Objection, that's irrelevant, cost me hearsay.
Overruled.
Yes, you asked me to look at those photos and see how they compared to the gels I had, or the copies.
I'm sorry. And you came back after lunch and you handed my pictures back to me and you said, these are great. I wish we had some of these, didn't you?
Here's, we're talking about the computer, not the photos.
Sustain.
It's irrelevant.
You came back and told me these pictures are fine, didn't you?
Objection, it's irrelevant, cost me hearsay.
Overruled. That's not irrelevant.
Actually, the photos, they're, as far as showing the ladders and what the samples are and the strong bands, they were excellent photos. As far as the weaker bands, you need to actually see the gel to be able to capture the weaker gels and to be able to visualize them with your eyes.
Move to strike is non-responsive.
Overruled.
Did you tell me any of that yesterday after lunch?
I told you parts of that, yes.
And I told you that for any picture that I showed, if you wanted to look at your original gel, you should tell me so, right?
I don't recall if you said that or not.
Didn't I say that in front of the jury here? Do you remember that?
I don't remember hearing it, but you may have said it.
And the two films that we sent, that we showed to the jury, were your films, not my pictures, correct?
That's correct.
Now I want to show you I want to show you 275I, which is the film with the dress samples on it, correct?
Objection, it's beyond the scope.
Overruled.
Okay.
And I put a Post-it on there with arrows above the two bands that you say are there at 24, correct?
That's correct.
And let me show you the substrate control that Mr. Harmon asked you about, which is 275Q. The band in the substrate control lane, have I put a Post-it with an arrow above the band that you say isn't a band?
Objection, it's argumentative, it's convoluted.
Overruled.
Well, the band that you say isn't a band, but it's not a band. That's why I say it isn't a band. This is one where we were talking about it yesterday, where there's this little glitch in the gel. And if we could pass it around to the jury for them to look at, that would probably help.
You see something there that looks like a band?
No, I don't. I see an artifact in between these two lanes.
You see an artifact that looks like a band.
No, it does not look like a band.
You can see something there that looks like a band, and you can't see, what you can see on the dress is much fainter than what you see on the substrate control, correct?
No, that's incorrect. This is not a band. And it's not a band because it's not a distinct banding pattern. It also falls within two lanes, and you could tell it's just I don't know how else to describe it besides a blip, but if you could show it to the jury, I think that would help.
Yeah, I like to put these on the Elmo side by side if it's good.
All right.
Let's try one at a time. We can't fit them both on here. Let's try 275Q, the substrate control first. Can you zoom in on it?
Would it be okay if I went to the podium?
Well, let's see how it projects first on the monitor.
Oops, that's upside down.
All right, can you see the area right below where my post-it says no band?
Yes, I do.
And that's what you're saying is not a band.
That's correct.
Now let's look at the dress. Now, you see that area? You're
Yes,
calling
I do.
those two bands, aren't you?
Excuse me?
You interpreted those as being two bands there, didn't you?
Could you put it into real life
Pick it up.
instead of magnified? Yes, and as when I was talking, or when Mr. Harmon was presenting the gels, I'm asking me to explain some of the fainter ones. I was saying that it's difficult to see those fainter bands from when they're projected up on the screen, and that you actually have to see them. It's just like slide presentations. Sometimes you lose some of the contrast when you put something on an overhead such as this.
Eric, will you pass these to the jury?
Yes.
Number 7?
No, you need to talk to the attorneys.
Mr. Blasier, I think it's best.
Hold
I
on,
don't-
there's no question pending.
Eric, can we also have a white sheet of paper, makes it a little easier to see?
No, they have their jurors' notebooks. collect those items from Deputy Russell. All right, thank you, counsel. Proceed.
Ms. Montgomery, these slides that we just showed the jury, this is what you submitted to the court as evidence of your testing, correct?
Do those have the evidence labels on them?
I'm sorry? The two that have the labels.
Yes, those are the two.
Now, cross-hybridization. I want to ask you a couple of questions about what Mr. Harmon asked you. Under what conditions do you get cross-hybridization so that you have a 1.3 dot show up?
Cross-hybridization can occur when there's a slight difference in the temperature of the stringency wash during the typing process of the DQ alpha. And I believe Dr. Cotton may have gone into this in a bit more detail. And if the temperature is slightly off, then you could get some of this weak dot, some of the weak dots occurring within the sample.
There are controls built into the system so that you don't have temperatures too low, correct?
Well, we calibrate our water bath and we check it with a thermometer. But sometimes if the water level's not high enough, then you could have a subtle or a slight difference in the temperature from between where the strips are and to where the water level ends and then where the top of the tray is.
What does the Amplitype User's Guide say with respect to cross-hybridization and when it can occur in terms of how much DNA you have to test?
The user's manual, actually if I could refer to that.
We refer you to section 6.2.3.
Yes, they talk about cross-hybridization and how it can occur when when you develop your strips for too long or too much DNA is added into too much DNA is amplified. And these are two other ways that cross-hybridization can occur.
Does the manual say that it can occur when you develop your pictures properly and don't use too much DNA?
When you develop your pictures properly?
Well, let's talk about one of those at a time. If
That's a
you use the
question.
appropriate, I'm sorry, if you use the appropriate quantity of DNA, you shouldn't get that, right?
No, that's not what this says.
Well, why don't you read it to us?
Would you like me to read the whole paragraph to you?
Yes.
Okay. It's section 6.2.3 of the Amplitype User's Guide put out by Roche. There's a Cetus emblem because Cetus was the original company and it was bought out by Roche. And in the supporting material section 6-5, it talks about typing of large amounts of amplified DNA. It's a long paragraph.
Go ahead.
Amplification of samples containing high levels of starting DNA, parenthetically, greater than 30 nanograms, generally results in large quantities of amplified DNA. Hybridization of very high concentrations of amplified DNA to the probe strips can sometimes lead to the detection of faint background signals, much weaker than the CDOT, which is due to non-specific, quote, cross-hybridization, unquote. Cross-hybridization in this context refers to the weak interaction of a probe with a DQ alpha sequence, allele, that is not perfectly complementary. This occurs more with the subtyping probes than with the typing probes, because the subtyping probes detect differences between the alleles of only one or two bases. That's only halfway through. The extent of cross-hybridization, even with very high levels of amplified DNA, is so low that any faint background signals only appear after lengthy color development. These nonspecific signals do not appear if the color development reaction is stopped with a degree of coloration of the specific dots appears to have reached a maximum.
You can stop there if you like, unless you want to read the rest.
Yeah, I think we should read the
Okay.
rest. Some samples having very large quantities of amplified DNA require only 5 to 10 minutes for maximum coloration. And our laboratory, we develop between 20 and 30 minutes. Development of color beyond this point, overdevelopment, can also lead to high strip background, which decreases contrast. And that's one thing our laboratory, Dr. Blake has noted that we should stop our color development a little earlier than we do.
Mr. Harmon told you to use Dr. Blake's name as many times as you could, didn't he?
He did not tell me to use Dr. Blake's
No,
name as
he
many
didn't tell.
times.
So the manual tells you that you shouldn't get these dots if you develop your film the appropriate amount of time, doesn't it?
Well, it's not film. What we're talking about are strips, and those are the membranes, the thin membranes that had the dots on them, the 1 dot, the 2 dot, the 3 dot. So we're referring to strips, not film.
The manual says that you only get that phenomenon when you develop it for too long, correct?
What that says, the manual says that's one reason why you can get that.
Does it give any, and it also says you have to have a high molecular weight of DNA before you see that phenomenon too, right?
No, it said that a high level of DNA. And
Was
that's
that-
one way that cross-hybridization can occur.
High level means a lot of DNA, doesn't it?
Yes, it does.
And in the mixed samples in this case, you had very low levels of DNA, didn't you?
That's correct.
Now, does it describe any other way you get cross-hybridization in here other than those 2 ways?
Not in that particular manual.
And this is put out by the manufacturer of the kit.
That's correct.
Now, Dr. Blake's article on casework analysis, would you agree that that says that you don't get cross-hybridization unless the temperature is too low, at 54 degrees rather than 55?
Yes, I believe the casework, the article he's referring to, it's the 1992 publication by Dr. Blake and some other individuals, states that with changes in the temperature that cross-hybridization can occur.
Now, let's assume hypothetically that you can get cross-hybridization at lower levels of DNA. Would you agree that what that results in is giving you 1.3 dots that really aren't there? I'm sorry, that don't represent any DNA?
Well, I think we need to remember that these dots are very faint and they're not interpreted as part of the results. These 1-3s are outlines or hints. If it's anything substantial and there's a question, the reanalysis should be conducted.
So these are the hints as opposed to the possible traces.
Well, you're bringing possible trace into the way the D1S80 is described. The hint as opposed to a trace. If it's trace, then you want to re-examine those samples.
Now, when you have a trace, you want to re-examine them?
Yes, one should re-examine if there's a trace amount.
We have the proficiency test. Let me show you Defense 1172A in yellow. Now, you recall, Ms. Montgomery, that this is the second time that you ran these proficiency samples, correct? I'm sorry, that's the first time.
Yes, that's the first analysis.
And you got 1 hint and 1 trace. You got a hint in QC839 and a trace in the positive control, correct?
That's correct.
So you did it again. Would that be the reason why you did it again?
No, I don't believe that's the reason why I did it again. I would need to see that whole case file to determine why subsequent analysis was done on these samples.
All right, and you got nothing in your evidence samples, the actual proficiency samples, of any hints or traces, did you?
That's correct.
Now let me show you 1172B.
Would you pull the microphone closer?
This is the second time you ran those same samples, isn't it?
That's correct.
And you got 2 traces in your proficiency evidence samples. Didn't you not? Didn't you? Actually, you got 3, didn't you?
Yes, that's true. But if you look at the controls on that strip, the positive control and the QC samples, there was nothing indicated there. And as far as the type that was reported out for these samples, sorry, I can't. On sample 433, the reported result is a 1.2, 3. Those trace amounts in the trace amounts of cross-hybridization were not reported out. They weren't significant to the analysis.
You characterized them as a trace when you read the dots, didn't you?
Yes, that's what I wrote.
And you didn't redo that one, did you?
No, I did not.
And your quality control showed, I think you just indicated the quality control worked fine. That shows 2 hints, doesn't it?
Yes, those are hints or, just a small amount of color developing in those.
And this is a proficiency test that you say you got the right answers.
Yes, I did.
Can we have the glove board, please?
Yes. Boards,
Well, actually, let me have you without that. We have the 1173C, please. PowerPoint. Ms. Montgomery, yesterday when I showed you this, I asked you whether the stains G10, G11, and G13 were in the wrist area, didn't I?
I believe you did,
You
yes.
said they were.
Yes, they're in the lower portion of the glove.
In the wrist area, aren't they?
I believe that's correct.
So where I have circled is the wrist area, isn't it?
Well, yes, that's the lower level of the glove. One would call it a wrist area.
Okay. Now, the upper area of the glove, is it accurate to say that the various samples that were tested, that Mr. Simpson was excluded from any blood stains on that glove up around the finger area where someone might grab the fingers to take the glove off?
Yes, there were areas in the finger region that were tested, and there was no 25 allele detected in those samples.
And there was no, Mr. Simpson was excluded from any samples in the palm area where someone's finger might make contact if they were holding it with the other hand.
So
Well,
that's not an evidence that they were all tested, John.
sustain.
You took a large number, you tested a large number of samples from that glove, didn't you?
Gary Sims examined the glove, and I guess I should note that for G11, it was near the wrist notch. It was termed the outside palmar surface. And as I stated, Mr. Sims looked at all these samples and extracted them, and then I analyzed them for D1S80.
The reason for taking so many samples was to get a representative sample from different parts of the glove, correct?
That would be one reason to test various areas, yes.
And various areas were tested, and Mr. Simpson was excluded from everywhere on that glove except the wrist area, correct?
Well, as I stated, the wrist and near the wrist area.
Ms. Montgomery, have you ever taken a pair of leather gloves off by pulling them off at the wrist?
That's irrelevant.
Have you further
Sustain.
questions?
Mr. Harmon?
Keep that up here for a second. Come back to that in a second. Could you cut that and then we'll come back to that? I just have a couple of questions, Ms. Montgomery. The cross-hybridization, when you were reading from the user guide, there was something in there that I think needs to be clarified. I believe the exact words were that this cross-hybridization occurs more with the subtyping probes.
Yes, that's correct.
And could you tell the jury, just so they understand what that means? What are the subtyping probes that were used in this case?
Well, the subtyping probes, there are 4 nominal alleles, and this is the 1 allele, the 2 allele, the 3 allele, and the 4 allele. And then there are also subtypes, and that's the 1.1 and the 1.3 and the 1.2, but the 1.2 has to be inferred because there's not a specific probe for that 1.2. So it's more common to see the cross-hybridization occurring with samples of the subtype.
Can we show 1173C? Could you come back here, Ms. Montgomery? Okay, what I'd like you to do is, just so the jury can appreciate what this means and doesn't mean, you know the symbol for circle with a line through?
Yes.
Could you put that over the no genotypes consistent with OJS, please? And maybe we need, is that
Whoops, wrong way. Is that what you'd like?
Yes, and if there's enough room, could you write down below that, let's make this line as thin as possible because they're kind of beefy there, down below, genotypes consistent with defendant, if you can fit that in there. Or just types consistent with defendant.
This is like one of those boards.
Does that make you dizzy?
It's very difficult to write here. How's John Madden do this? Can you read that?
We'll remember what that means. Could we capture that, Your Honor? And I don't know if that's 1173C1, or I'm not sure how we number this one.
This one would be a prosecution exhibit.
Okay. Okay, Ms. Montgomery, we're done with that now.
276.
Could I have 275C back up there? And this is my last few questions of you. Ms. Montgomery, while this is the substrate control, the 50C, I'm pretty sure that's the one it is. Or no, that's the, I'm sorry. The gel that had the 50 control on it. It's 275Q. Now, we just need to get back to a little basic here. You put the samples in all the way across the top, and they move in one direction, is that right?
That's correct.
I believe one of the things you said is that whatever that is, it's not a band, is that right?
That's correct.
And one of the reasons it's not a band is that it's not in a lane. Is that true?
All right, that's one of the reasons. I think you'll want to clear the telestrator. Yes, and it doesn't have the definition of a band.
Well, let's just focus on where it is. It's your opinion that it's not in one of those lanes, is that right?
That's correct.
Now, these bands, they're DNA. They're started out, they're DNA material, right?
Correct.
I think we heard amplicons. There's amplicons in there?
Correct.
Hold the microphone closer, please.
Now, can these things move sideways?
No, they're moving down through the gel.
I mean, suppose it was a band full of amplicons from a very willful person. Could they, and they wanted to turn left, could they do that?
No, they do not have control over themselves.
They move in one direction,
That's correct.
and one direction only.
Correct.
Thanks. No further questions. No.
Mr. Blasier? All right, Ms. Montgomery, thank you very much. You're excused. All right, let me see counsel without the court reporter, please. Mr. Harmon, Mr. Scheck, my understanding is the next witness is Colin Yamauchi, correct? All right, and there's some issues we need to resolve before we get to Mr. Yamauchi.
Yes, Your Honor.
All right, Mr. Harmon. No, let's take the other man first.
Me first, Your Honor.
You're the one who told me it's going to take a bit, so.
Oh, okay. Actually, it may not. Maybe we need to recap our off-the-record discussion yesterday, because I think it's helpful to see where we started and where we're going to end up with this, Your Honor. Dr. Gerdes has been retained as a defense expert in this case for some time. He's made laboratory visits to LAPD, and I believe in January, in December, he looked at many things in the lab. In January, he photographed many records in the lab that were pursuant to court order and legitimate areas of inquiry by Dr. Gerdes. And as you know, we have consistently requested discovery material to be provided to us by defense experts whom the defense has actually put on their list, which one would assume means they have a reasonable expectation of calling them.
All right, Dr. Gerdes is on the witness list.
Dr. Gerdes has, to my knowledge, has always been on the witness list in this case. And I don't think we've ever gotten anything from him until, just coincidentally, before Mr. Yamauchi was about to hit the stand. We were given 6 pages on May 22nd. I'm not sure what today's date is, so that was just a couple of days ago. And it's a tabulation by Dr. Gerdes of things that he apparently reviewed and photographed and his opinions about them. I'm well acquainted with Dr. Gerdes, and I'm well acquainted of the nature of his observations and evaluations of things, but it would appear that most of these things have nothing to do with Mr. Yamauchi. However, a significant number of them do. My ballpark count was 40 to 50 of these separate items relate to Mr. Yamauchi.
Why don't you give me an example of what these quote-unquote items are?
Well, see, one of the problems is that this is what Dr. Gerdes has seen. This is his version of what he saw, but these are hybridization strips and sheets for PCR typing done by LAPD in general, and many of them, they're not all Mr. Yamauchi, because he's not the only one that does the PCR DQ alpha typing. So these are, it is my understanding that Dr. Gerdes has only seen a hybridization sheet and the strips that are reflected in that hybridization that show the typing results and interpretations and the conclusion of the analyst. These items cover the time period, they go from 93 to 94, which is the time, I think, October 93 to through the latter part of 94. And some of them reflect actual, or yesterday when the subject was broached, Mr. Scheck represented to you that these were LAPD's validation studies, and that's not necessarily true. It's only partially true. And then I believe he corrected it to say, well, it's validation studies and casework. There are two issues here. Are these things relevant? Are the ones that don't affect Mr. Yamauchi at all, where he didn't participate in any of the testing, are they relevant at all? And I'm assuming that absent some specific offer of proof, they're not relevant, particularly when there are things that Mr. Yamauchi may not be familiar with, I mean, you can't make something relevant by asking a person about something they haven't done and then forcing them to look at it and then say, what do you think now, Mr. Yamauchi? There are a number of these things that as I said, 40 to 50 of these strips and sheets that do relate to Mr. Yamauchi. What the court is not aware of is Mr. Yamauchi accepted his first PCR DQ alpha case in October of 1993. When I looked at this, I tried to segregate what Dr. Gerdes claims he saw with those dates, because, you know, that could get relevant if given the right showing or offer of proof. And it would appear that about 18 of these strips, sheets, were after Mr. Yamauchi accepted his first case, and 30 of them are before he accepted his first case. And I provide that to the court to assist the court. Once you hear whatever the offer of proof is, Mr. Scheck alluded to the fact that he was only going to ask a few general questions. And, you know, we might save a lot of time if he specifies what the questions are. There may not be any objection to this. We would welcome Dr. Gerdes coming in and testifying about this. If he couches his testimony correctly, it could be highly relevant, and we're anxious to hear that from him. But cross-examining Mr. Yamauchi about things that may or may not be relevant, most of which have nothing to do with him, I think absent some specific offer of proof would be inappropriate. But Mr. Scheck assured you he only had a few questions. The problem with the few questions are if they're the kinds of questions that open it up to requiring us on redirect to go through each and every one of these, we'll be happy to do that. Clearly, Dr. Gerdes is misinformed on some of the things that he said in here. I'm not misinformed. This is what he does for a living. But I think absent some specific offer of proof, I timed the amount of time just on cross that we spent with Renee Montgomery on her proficiency test. It was about 20 minutes. So if we multiply 20 minutes by 40, we could spend days just showing that Dr. Gerdes' representation or his interpretation of this is at best misguided or misinformed, and we'll be happy to do that. One of the problems is this requires a massive compilation of information. Some of these are actual cases, and we're not even sure that they're pending or not, so there may have to be some redaction to protect the names and identities of parties. So if it's a simple proposition that Mr. Scheck, there's nothing, we're not trying to hide anything, but the way this gets done, I think, is important, and we will do whatever we can to present it fairly. But I think those are the caveats that, absent some specific offer of proof, at this point, it may well be irrelevant. One could imagine Mr. Matheson being cross-examined about each and every conventional serology case that he's ever done. Certainly, that was not requested, and I'm sure you would not have allowed that. And absent a specific offer of proof, you shouldn't allow it in this case either, Your Honor. I believe as well, if there is to be a specific offer of proof about that relates to this material, then I believe the defense should provide us with the additional material that Dr. Gerdes refers to in the 6 pages that he provided us. Somehow, we have been forced into the position, in terms of reciprocal discovery of this case, that defense witnesses who are on the witness list for months and months are somehow shielded from providing material because there's a clear pattern to this, that somehow the defense has been allowed to hold back material because they have convinced you in some way that it would effectively undermine their cross-examination of our witnesses, or in the alternative, that in spite of the fact that they have expressed their clear intention to call these witnesses, that in camera discussions, it is my impression that they have convinced you that even though they've put them on the list, which is a clear manifestation of their intent to call these people, that they have also alternatively told you, well, we're not sure that they're going to testify because we want to see how well we do on cross-examination, and if we give the prosecution the material that we intend to cross-examine their witnesses about, we will not be very effective in our cross-examination. And your court orders clearly reject that proposition, but it's clear that's what's going on in this case, Your Honor. So if there's an offer of proof, I'd like to see the additional material that Dr. Gerdes, where he says, see analysis, discussion for detailed explanation. We don't have that. And you know, honestly, if there is an offer of proof, we'll need to have that. We'll need time to review it so that we can have an intelligent discussion about the materials that have been withheld from us for much, much too long.
Mr. Scheck?
Your Honor, I don't know why these things have to take so long. We had a discussion about this. The record's clear. First, we got some validation studies. We were able to review those strips. Then, in the middle of January, we were able to look at more of these strips. These are Dr. Gerdes' notes. What they reflect in the chart, as Mr. Harmon indicated, is that there are these dot blot strips. At LAPD, they record what they see and what they don't see. This is just a chart where Dr. Gerdes indicates this is what is seen. I say this is a contaminant. They're not a contaminant. Out of an abundance of caution, it struck me that these notes should be turned over. It's not a final report to avoid all this. The bottom line here is that Dr. Gerdes and Mr. Yamauchi sat there and went over these strips one by one. As I indicated to the court yesterday, I have no intention of going through these strips one by one at all with Mr. Yamauchi. The only question I'm going to ask him, and where I think it's relevant, is I'm going to ask him some general questions about whether or not he thinks the LAPD DNA laboratory has a problem with contamination. And we'll hear what he has to say, and we'll accept his answer, and it's not my intention to go through these strips with him one by one in terms of the reading, but I just thought out of an abundance of caution I should give them Dr. Gerdes' notes, which I'm not entirely sure I'm obligated to turn over, but I thought I might as well just to make it clear to them. And this is something that Dr. Gerdes went over with Mr. Yamauchi and explained that there are two different views, as is coming out in the testimony, as to the meaning of dot intensities and what significance that has, whether they're contaminants or not. That's all. So I'm just going to ask him that one general question that I indicated to you before, or the questions along those lines, and I'm not going to go through each of these strips with him one by one. I have no intention of doing it. So I think it saves us all trouble.
All right, we're going to call Dr. Gerdes to go through them one by one?
That's a different story. Yeah.
All right, then isn't there a, excuse me, Mr. Harmon.
I'm sorry, I thought you were going to.
Isn't there a comment in the 6 pages of notes that there's an analysis that has been prepared?
Yes, in fact, I think the court saw it, that if the court recalls, there was, we were turned over some but not all of these strips. So what we turned over to Mr. Harmon is an additional analysis of all the additional strips. Initially, we got just some strips, and those comments refer to notes I think the court's seen that are just general characterization summaries of what's on that chart, but not for everything that's on that chart, because he only had validation studies. And then in January got additional casework, and he hasn't done the additional summaries integrating everything else that he has. We'll get that expeditiously, but all the data is there with respect to that. It's just a question of graphing them. But that's what those comments refer to, and I think if the court goes back and looks at the notes, you'll see that's exactly what it is.
And that's already been turned over to the prosecution?
Which part?
The analysis.
The raw data has. The overall analysis of each of those hasn't been done yet. Do you see what I'm saying? In other words, he got some of the data, and the comments that Mr. Harmon is referring to are not his final report, because it doesn't refer to all of the data, it only refers to part of the data. What we gave Mr. Harmon are all of the data, all of his calls. It's just a question of characterizing, adding up, and summarizing it. That's all. It's just a question of making charts. So, but the point is that, he's been very busy. We're working with him on charts, and we'll get the charts. But none of this is going to be gone into with Mr.
There's no
Yamaguchi.
report?
No. Not in, how do you define a report? Report would consist of the raw data and the charts. Is there a final report? No, we've indicated to you there's no final report. Was there an interim report based on part of the data? Yeah, and we showed that to you.
Have you shown it to the prosecution?
Excuse me. Mr. Blasier had. Mr. Blasier did. He told you about this, about the interim report that was in draft form, that wasn't a final report. That's what he tells me. Not on all the data we gave him, which we didn't have. So that's all.
Let's address the first issue first. Mr. Harmon, what's your comment on the offer of proof as to the questioning of Mr. Yamauchi?
Well, questioning is questioning. If I have no objection, if that's all he's going to ask, and we don't, and if he doesn't like the answer, get in a huff and go on with other things, or pursue it, that's fine, Your Honor. That's when I heard that yesterday, I thought if we get a commitment, we could save a lot of time on this. But it's got to be a clear commitment. Otherwise, we have to talk about subject 2 as well, and I'm anxious to do that as well. So, can we move on to that, and maybe Mr. Scheck can craft his questions, and
All right.
That's no problem. But subject 2 relates to that, Your Honor. Can I talk about that?
Sure.
I just want to indicate to the court that the board discussion is going to take some time on one of the boards.
Well, we'll see. Do we have those available, by the way, the boards you can use with Mr. Yamauchi?
If they were here, we left them here, I think. Yes, Your Honor.
All right.
I'm not one to be shocked when I hear that what I knew was going on is really going on, but if I heard correctly, they've had discussions with you. I mean, it's clear by the sequence of the reciprocal discovery requests, and I alluded to this the other day with the cut-up notes that we got about from Baden and Wolf and Lee, that there's a lot of doctoring going on. And it's clear that this whole manipulation, it's a contrived, perverted attempt to withhold what the voters of this state afforded us, and that's the right to a fair trial.
Well, Mr. Harmon, let's not go down that road. We've had this discussion
Well,
once
we're down
before.
that road,
Wait,
Your Honor.
Don't interrupt me, Mr. Harmon. The problem we have is that the people who crafted this did so inartfully, and they left a lot of loopholes.
Well,
But I'm stuck with it, as are you.
Well, and they rely on judges to realize what it meant, Your Honor. And what it didn't mean was that they would spend time on charts and say, don't write a final report, because once you do that, we've got to turn it over. So let's just spend time at $150 an hour making up charts and things. And so when you walk into court, make sure your report is only dated the day before you walk into court so we can justify withholding it. But I heard Mr. Scheck say that you've reviewed some notes.
No, I haven't reviewed notes. I've been told about notes.
Well, I haven't been told about any notes. None of us have. And somehow, Dr. Gerdes said, see analysis discussion for detailed explanation. It doesn't say the one I haven't written yet. It doesn't say the informal one. It doesn't say the casual one. It says, see it. And we haven't seen it. This is all we saw. It was dated May 22nd. And this is the tip of the iceberg. This is going to happen over and over again because we don't have anything from the defense except cut-up notes. That's all we have. And so I think we need to call a timeout to the proceedings, Your Honor, respectfully, and review all of this material, because we were entitled to have this before the trial began. We
Well,
were
Mr.
entitled
Harmon-
to consider it.
Mr. Harmon, before we get off onto that discussion, if you recollect, I have issued an order regarding all of these experts' reports, ordering them to be disclosed as soon as they're available. I also gave counsel warning that I would be very wary of the subterfuge of telling an expert witness out of their normal practice not to write reports. And I, in fact, cited the one case I was able to find where counsel were sanctioned for that very procedure. So I'm aware of that issue. If it comes to pass that there are reports or that conclusions were reached and there was a deliberate manipulation of the process and instruction to the witnesses not to prepare reports to avoid discovery, then those witnesses will not testify. And that's going to be the sanction. And that was an order that I made early this year.
Well, I think you're in a good position to say, tell Gerdes, have a nice life, but they've sandbagged us with
That's
it.
quite possible.
I think you heard enough today to do that.
That's quite possible.
I'd be happy to see a judge resort to that, because it's totally within your judgment to do that. And I think what happened today may haunt them, and
It
we will
could.
remind you at every turn that clearly what they told you is they'd rather spend time on their charts than writing a final report. He hasn't gotten any other data since January. I know he's a busy man, but he's not too busy to be making charts for them, but he's too busy to write his final report. So, don't get me wrong. We'd love to have these guys come in. We don't want faceless people's names being injected in here. But to deny us this kind of material so that we can absorb it into our presentation really frustrates the whole purpose behind it, Your Honor. So I think we've seen the tip of the iceberg, and I'm anxious to see the bottom of it, because it's much bigger than any of us appreciate.
Your Honor, I have every confidence that you'll have no problem with this. I'm really restraining myself, because these long diatribes and these attacks and these on what witnesses are going to say or do and the quality of them, I mean, it's just irrelevant.
Well,
I
Mr.
understand the court's
Mr. Scheck,
concern.
I'm a little skeptical for this reason. I expressed this skepticism 2 months ago, that it's hard for me to believe that expert witnesses of the caliber that I've seen on the defense witness list haven't prepared reports. It's hard to believe that counsel could proceed to make opening statements and make certain representations as to what's coming in the defense case without having reports to base those statements on. I'm just telling you, I'm a little skeptical.
I understand what the court, but we've had meetings with the court about it. We'll explain it, and I think that you'll be satisfied. I don't think you'll have any problems with it at all, especially with respect to this and in terms of Dr. Gerde's data and the charts and what his testimony is going to be in his reports.
But these notes say C analysis.
Yes, and we indicated exactly what that was, an analysis of validation studies. There was additional data that he saw in January after that was repaired that he has to integrate, which he hasn't done yet. And obviously, given the court's concern, we'll have him produce his integration post-haste. But the essence, I think it'll be very clear. The notion of a report, we're talking about looking at dots on a strip, and what you'll see is that there's a principal difference here between those people that believe that certain kinds of manifestations on these strips represent contamination, and those that say we can ignore it. And that's a considerable, that's the principal concern. I think the court's going to see that coming out. It's no big secret to anybody, and it's no big secret to Mr. Yamauchi, because Dr. Gerdes went and said, look at this, look at this, look at this, this is what I think. It's not a secret to Mr. Harmon.
All right, let's see the boards.
The board that I think we should address first, Your Honor, is one that concerns Dr. Lee's examination of the socks. And I have some serious problems with this board for a few reasons. The principal reason is that what it depicts isn't true. And first I'll state the factual background, and then I'll state the legal objection. As the court recalls, the biggest problem that we've had in this case, and one of the most remarkable and unusual aspects of it, is that we're in the middle of trial before the defense is even allowed to examine evidence. And there was a point where the prosecution said that they wanted to send the SOC out for EDTA testing to the FBI. And we had been tried, they did not refuse to send the SOCs to Albany. And then, as the court, I'm sure, distinctly recalls, they said, I interjected, well, can we, they refused to send it to Albany because they were going to send it to the FBI, I believe, for testing on EDTA. And I said in our chambers conference, well, if we can fly Dr. Lee, if we can we see it in the morning before the courier takes it out to Washington? And you looked at the prosecution and said, well, if they can do that, they can do that. And we managed to find Dr. Lee at Seattle in that American Academy of Forensic Sciences conferences. We called him at 1 in the morning, and we flew him down at 6 in the morning, and then went over to the LAPD in order to examine the SOC and go over a list of items to be sent to Albany with Mr. Hodgman. And what occurred here is that, and Mr. Hodgman, I'm sure, will verify this, we were told that the courier was going to be flying out at a certain time, and there was no
Mr. Shack, let's
Yeah.
get to the chase. What's inaccurate about this board?
Well, what's inaccurate, in particular, and I'm a witness to this, as is to Mr. Blasier and Dr. Lee himself, and we're the only defense representatives in the room. You see where it says, examined other socks, same gloves? That's not true. He changed his glove between those socks. I was watching. Mr. Blasier was watching. Dr. Lee says he did that. That's not true. Just permit me a moment, but you have to, and then there's this business about no lab coat, et cetera. The reason I have to give you the factual background, and Mr. Hodgman will back me up, is we're sitting in the front lobby of the LAPD SID lab, waiting to get our chance to see the SOC, told that there's this deadline certain when the SOC has to be whisked away from Dr. Lee and he can't examine it anymore because the courier is going to take it to Quantico, Virginia. And we're waiting and waiting and waiting and waiting. And there's big delays where Mr. Harmon is inside there, waiting to make arrangements for us to look at the SOC, and we've brought our own microscope there. And then finally, at a time when it would only, according to their time period, have permitted something on the order of a half hour to 40 minutes to look at the SOC, were allowed into the room. Now, Mr. Hodgman will be my witness as to that, because we were asking, well, what's the delay, what's the delay, what's the delay? And he's saying, I don't know, I don't know, I don't know. Let's talk about some other matters in the hallway. The reason that that bothers me is that if we had even bothered to ask for a lab coat, it was our fear that these guys would take another 20 minutes to get the lab coat, and he'd have 15 minutes to look at the SOC. But putting aside the lab coat issue, the real question is, he changed his gloves. It upsets me a great deal to even have that in there. That's going to be, ultimately, when Dr. Lee testifies, an issue of credibility. Let me cut right to the legal issue. The legal issue, it seems to me, is the following. This board, through this witness, is not arguably, and this testimony that he didn't change his gloves, they claim, between the examination of both SOCs, is only relevant on the issue of whether or not there was any cross-contamination of the SOC at this point in time, or any contamination of the SOC. I don't think that they contend that anything that Dr. Lee did to that SOC contaminated it or created any trace evidence problem or any chain of custody problem. The defense attack with respect to when blood got on the SOC is all subsequent to this examination anyhow. So in terms of whatever probative value this testimony and this board has through this witness at this time, it's minimal, if any, because that's not the purpose for which this is being offered. The purpose for which this is being offered at this time is in anticipation that Dr. Lee will testify, and Dr. Lee will testify about proper procedures for handling, examining items in a laboratory, and that that is, they're intending to impeach him with his testimony when he comes in advance of his testifying. Now, it seems to me that if they want to raise this factual issue, that's the time to raise it. It's not probative through this witness at this time to anticipate what another witness is going to testify to. And they're not offering it for anything with respect to the chain of custody or contamination with respect to the sock.
So are you raising the specter that we're going to see both you and Mr. Blasier testify as defense witnesses?
Oh, what else can we do? They restrict our access to this. It's myself, Dr. Lee, and Mr. Blasier who are sitting there looking at it. And believe me, I was watching this because I know what the issues are in this case, and I know what proper procedures are, and I was watching this like a hawk. So the only witnesses that can even begin to, I'm going to in the position where I'm going to have to start asking Mr. Yamauchi if he's testifying to this at this time, which has minimum probative value in terms of what the purpose of offering it at this time is. The only defense witnesses in the room are lawyers who can say, this ain't true. So that's a problem. That's a 352 problem, it seems to me. And if this issue is to be visited, it seems to me that the appropriate place to visit it is that they can ask Dr. Lee on cross-examination when he testified whether he changed gloves. They can call a rebuttal witness to dispute that, and we could take it from there, and that's the appropriate time and place. To get into this now is an undue consumption of time. It's going to be confusing. It's at the wrong point in time in terms of its probative value, and it's going to require lawyers to be witnesses and to have the lawyer who was sitting right next to Dr. Lee doing this cross-examine him about it, which is not what we like to do. So it seems to me that this board and this area of testimony from this witness should be avoided at this time.
Mr. Harmon?
Mr. Scheck has a short memory. There were other non-lawyers there. I mean, Dr. Lee's not a lawyer, so he can testify about what he's got to say. But there were, I don't even remember all the people that were there. I've never seen so many people staring at two socks for as long a period of time as we did. It was an interesting session. There's a simple issue that this addresses, and Mr. Scheck skirted around it. I mean, one of the implications of all this heightened sense of awareness is they didn't have to do it then. They chose to do it then, and we allowed them to do it. You suggested it, and we allowed them to do it. So, but if you take Mr. Scheck's comments at face value, his comments suggest it's okay to be sloppy if you don't have a lot of time, and that's clearly the attack they're going to make on Mr. Yamauchi, that he was sloppy because he was in a rush to either incriminate or exonerate. So there's a little having it both ways in those comments. There's a very basic legal issue involved in this. Mr. Scheck mentioned it. This event is part of the chain of custody of those socks. Those socks went to the FBI lab that day. And we don't want anybody undermining the clear, unequivocal tests that show that there's no EDTA on those socks. And if there are any quibbling about it, Dr. Lee was there. He handled them. We want to be able to document what he did in case they want to try to put the spin that they've been spinning on our clear, unequivocal testing on the socks for EDTA. That we are entitled to demonstrate this just like we did with 47, 50, and 78. They took things, they're part of the chain of custody of those things, and they're clearly not irrelevant at this point in time. That is the primary reason that they will be presented. So to address Mr. Scheck's concern, Dr. Lee's a non-lawyer. There was a photographer there.
Whose photographs are these?
These were taken by somebody from LAPD. I don't remember which. John Taggart. I mean, we had our photographer there because, quite frankly, we get kind of tired of people saying that LAPD doesn't do things well when here's Henry Lee doing things just the way they do. You be careful. You change gloves when you have to. And so here was a chance to show that the much anticipated defense expert, he does things just the way they do. You be careful. Sometimes you touch things, sometimes you don't. And so that's why we took them, never dreaming that we'd be having this intense discussion at this point. you know, Dr. Lee manipulated the heck out of those socks. It's all standard practice, and now it's documented. But the real problem that they have is it is an event in the chain of custody of those socks. And you will see when the FBI testimony from the EDTA comes in how important it is for this jury to appreciate all the hands that those socks went through, just in case they try to put the spin on those unequivocal results that they've been struggling with for so long. So that is the simple proposition that we want to offer this for.
All right, let me ask you about the conclusion that it makes, saying paren, same gloves, same gloves, same gloves, as to photograph 3, 5, and 6, starting from the top. Mr. Harmon, Mr. Scheck takes issue with that as a matter of fact.
Okay. Well, you know, I'm in those photos, and I wish I could tell you I was paying attention to that. I wasn't. But Mr. Yamauchi and others who were on the photography side of the table, this is their observation. So it's another question of fact for the jury to decide, Your Honor.
All right.
But that is, I did not notice that because those socks were kind of boring to watch, and I wasn't paying attention to details. I was a little too close. So, but that is the representation from the criminalists on the other side of the table. And, excuse me, who were watching for that reason. So I can verify that again, because we certainly don't want to have that there if it's not true. But this board was prepared based on their observations. So I don't have a reason to doubt it, but if you'd like me to confirm it, I'd be happy to, Your Honor.
No, but Mr. Scheck indicates that it's his distinct recollection that that did not occur. So to allow you, his argument is going to be that to allow you to have the paren same gloves is actually argument and not just a statement of description of what's there.
Well, you know, I mean, I've objected to all these argumentative things. No genotype consistent with O.J. Simpson. That's a conclusion that they want to have a lasting image of.
But that's an undisputed conclusion as to that glove, as to that area on the glove. This is a disputed issue.
I mean, we have to agree on fact. I mean, I guess we've done this over and over again. You've made us put mixture, or you're going to make us put mixture frequencies up in our results when that's not our scientific opinion. So I don't blame them. But, you know, do they want to testify first and have you resolve it? I don't think there's any legal basis for that, Your Honor.
No, I don't. I agree with you.
That's what the fact finder's entitled to decide. And if we have made a mistake on that, they're entitled to think that we deceived them.
All right, if you want to use that, you can cover up the paren. No, don't interrupt me. If you want to use that, you can cover up the paren same gloves.
Your Honor, may I be heard in response? Just please be, I know that you've made one ruling, but if you just hear me on why this shouldn't be used at all, just hear me.
I heard you.
No, I mean, hear me in response to what he just said, because there's something that I'd like to emphasize that I think is relevant. If the court would just hear me on it.
Make it quick.
There is an indication there, no lab coat or hairnet, okay?
All right.
Now, the point here is going to be that I'm going to have to go into with this witness, and we're going to have to start calling witnesses. Maybe even the court's going to have to start issuing statements with respect to what was permitted and not permitted. I mean, I love the way that Mr. Harmon says, we allowed them to do it. You ordered it. You ordered it under circumstances that were extreme in the utmost. We're going to have to call Mr. Hodgman to the stand to talk about the delays in that front room while we were waiting to get in to examine this. I mean, that's what we're going to have to. That's what we're going to have to get into if this is gone into. All those facts and circumstances, and it seems to me that those are of. There's a 352 problem if you want to go into all of that.
Oh, I agree.
Now, my
I
other
agree.
suggestion to the court, it's not that I'm afraid of them testifying to what happened here at this particular point in time. My real suggestion to the court is when. The issue is as to whether or not the handling of these socks at this particular point in time has anything to do with EDTA issues, can be resolved when you hear that testimony. I don't think it does. I think that the whole point of this board at this point in time is that other issue I'm talking about, is a try to do a preemptive impeachment of a witness who hasn't testified yet. And that's where the 352 consideration comes in terms of my having to get into this witness, through this witness, all the facts and circumstances surrounding how that examination occurred and why no lab coat was accessible and why that had to be rushed, etc. And I'm going to have to ask all these questions of the witness in order to clear that up, some of which he may have knowledge of, some of which he may not, all of which are in good faith, all of which reflect our discussions, all of which I should be entitled to go into with this witness. Now, my suggestion is that in terms of this area, in terms of the 352 problems, the consumption of time, what the court would have to instruct the jury with respect to the circumstances of examination, is that if this is really going to be relevant to EDTA, then they can put them on, they can call a witness at another point in the case to testify to this aspect of the chain of custody or the details of this examination. That's my suggestion.
All right, but I think in any lawsuit, I think the plaintiff is entitled to present their case in the manner and order in which they determine. I'm not going to tell them when to call their witnesses,
Well,
other than my other rulings for discovery violations. All right, noted, thank you. Let's see. No, not yet. Let's see the other board. I take it we won't get to that board before noontime.
Oh, no, Your Honor. This is the PCR board? Is there an objection?
that's the only other board now. Now, Your Honor, just as a matter of simple courtesy, and in keeping with our past practice, I've been asking Mr. Harmon for a day and a half for a printout of this board, which I've received and we've all received on all previous boards, and the photographs that went into this board. And previously, we'd received all photographs. The boards were made up of photographs that we'd received prior to this. Now, I don't believe that we received these photographs, but most importantly, you see all of these photographs, I should say. My particular problem has to do with the bottom rung here, and that is Pipertech Product Gel Electrophoresis. Just in our experience taking 2 tours of the lab, the DNA lab, is that the first time that we took a tour with Mr. Yamauchi, and we were taken into the room where they did the product gel electrophoresis, which incidentally is back in the Parker Center. Back in Pipertech. They go to Parker Center, and they take the amplified product out, and they bring it back to Pipertech into I think they call it an equipment room. They changed the setup of of where they did the PCR product gels in a different place. Look different, all cleaned up. And I think these photographs are of that new area where they did it, not of the original area that we first saw, which I take it is where the actual PCR product gel electrophoresis analysis was done in this case.
Mr. Harmon?
Cleaned up, I'm not sure what it's cleaned up with respect to June 13th and June 14th and 15th. I don't know how to address that. They've been there, they've taken their own pictures, they can put on their own pictures if you allow Dr. Gerdes to testify, which I'm sure you won't. I don't know what to say, Your Honor. Should we have like amplicons marching around there?
Mr. Harmon, I as much as I enjoy your style, I don't know if you were watching the jury, but when you asked the question about can amplicons suddenly turn left, did you see the look on the jurors' faces when you said that?
No, you know, I'm old enough to appreciate what I do, and I appreciate your observation, Your Honor, and I understand.
Well, it has
I
about
appreciate the
it has about the
advice.
same effect sometimes.
But I mean, sometimes I'm
Right.
speechless. And
The
this is-
objection is that it's not an accurate photo of the location where the testing took place. Any comment on that?
That's not where the testing in this case took place?
That's how I understood the objection.
I mean, we think that it is. If it's wrong, then I'd be happy, you know,
He should talk
I
to
make
his
mistakes
witness.
all the time, Your Honor. If that's not the right photograph, I'd be happy to put the right one up there. But we've been there, we've walked through it, and if he can be more
Has your
specific.
witness seen this and told you this is the same place?
That's him in the photos.
Bottom one.
Sure, I know. I mean, we went around with him. I was with him that day, so.
Okay. If you're offering that it's accurate,
Let me just try to help him out a little bit. The first time we went through, it was in a different location, in a different place, in a different setup within that room. The second time that we took the tour, they said, we've changed the area that they did it, they gave it a wider space, they cleaned it up, they put it in a different place. My strong suspicion is it's in the second location, not the first location where they actually did the product gel in this case. It's a simple enough matter to ask his own witness what that's a picture of. I'm fairly confident. And certainly, I've never seen these pictures before. I was supposed to see them, right?
where's Mr. Yamauchi?
He's upstairs.
All right.
But we can get him.
Well, I have
now.
to give the court reporter a break. So we'll take a court reporter break, get him down here, have him take a look at the pictures, and hopefully we'll get some time in front of the jury this morning. All right, we'll take 15.